Okay. Hello, everyone. This is John Weber, President of Software Toolbox. Thank you for attending the August CSIA's webinar. Today's topic is about understanding the classification of those who work for you. Are they an employee or are they a contractor? Software Toolbox, a CSIA partner member, hosts and sponsors of the monthly webinars, helps SIs lower their risk on projects involving software by providing them a unique mix of off-the-shelf software products and rapid response technical support that minimizes the need for custom code and lowers field startup time risk. I would like to introduce today's webinar presenters, Mark Voigtmann, Gayle Skolnik, and Greg Dale, attorneys with Baker & Daniels. Baker & Daniels is CSIA's legal firm, and many of you know Mark for his informative yet humorous conference presentations. Mark has done substantial pro bono work for CSIA, for which we are very grateful, and also serves as the paid attorney of many dozens of CSIA companies and other automation providers throughout North America. Mark is probably the most knowledgeable attorney anywhere on the control systems integration industry. Gayle specializes in employee benefits and executive compensation, and Greg specializes in labor and employment law. And without further delay, I'll pass the presenter ball to you, Mark, and you and Gayle and Greg can get started with your presentation.
All right, then. Let me see if I can get my slides up here, John.
Yes, sir.
Giving it a shot. There we go. Hello, everybody. I hope you like that introduction. We wrote it ourselves. Independent Contractor Liability, What You Don't Know Will Hurt You is the title of our presentation, and I think it's very relevant. When I think of the average or typical control system integrator, I typically think of a smaller company, one that from time to time has to augment its forces, does not always have a predictable manpower need, and may flirt with the idea of bringing somebody or some bodies on their staff as a temporary worker and justify it by saying, well, they're just an independent contractor. So I'm joined by people that know about some of the bad things that can happen when you do that, and will help us navigate our way through the jungle of regulatory agencies. And let me just introduce them now. And I'm going to ask each of you to just tell me how you are approaching this a little differently, because I know you each have different areas of expertise. And we'll start with, well, there's me. Isn't that a good-looking guy? That's a different story. All right. Now, there's Greg Dale, another good-looking guy. And Greg, let me just ask you, how are you approaching this whole independent contractor issue that affects smaller companies?
Well, Mark, as a partner in the Labor Employment Group, I usually get involved in Department of Labor investigations, typically from the Wage and Hour Division, that look into whether a worker is properly classified as an independent contractor versus an employee status. Occasionally, those audits can happen not only at the federal level, but at the state level, departments of labor in the various jurisdictions. On occasion, we also get involved in tax side investigations, and those are typically handled by at the federal level by the Internal Revenue Service or the IRS, and at the state and local levels by the various departments of revenue and taxing authorities. And probably the third bucket would be private litigation, where they're typically initiated when somebody is separated from employment, whether they are an independent contractor or employee. Sometimes those cases can matriculate into claims that the person was misclassified and bring into the wrongful discharge or the wrongful separation case claims that there are various benefits or overtime, those kinds of things that should have been provided to the worker. So basically, those are the three areas that I see, from my practice dynamic.
Okay, and then from the other person that we've got with us is Gayle Skolnik. And Gayle, how do you approach this whole thing?
I approach it from a benefits perspective, and I typically get involved in a number of different stages. Sometimes I get involved in the planning stage when a company is thinking of hiring or retaining a worker and wants to know what kinds of benefits they can or should or shouldn't provide to that worker. And sometimes they also get involved in the preparation of contracts with workers. I also get involved in what I'll call the claim stage, when a worker who's been classified as a contractor or treated as a contractor claims that they were indeed an employee and that they are thereby entitled to certain benefits that weren't provided to them.
Okay.
And then also I get involved, as Greg does, in the investigation stage. Typically, it's the IRS claiming that a worker has been misclassified, or auditing a benefits plan and determining that someone is in the plan who should not be, or that someone who should be in the plan was not included in the plan.
Okay. So I get the impression that this whole landscape is one where if a company wants to designate a worker as an independent contractor, that the main worry has to do with regulatory authorities and government agencies getting involved, and somehow the company getting off the reservation in the view of those authorities. So let's do this. Let's create the longest list that we can, or at least a list that we can, of what federal and state agencies are typically involved in this regulation. Let's keep this brief, but let's make a comprehensive list on independent contractor issues, and let's start with you, Greg, if you would.
Okay, so let's go ahead, and we've mentioned the Internal Revenue Service a couple of times, so the IRS certainly would feature on that list. And staying on the tax side of things, you would want to add the state and local taxing authorities, so the state departments of revenue. Particularly, a lot of states are stressed right now with budgets, and we're seeing across the country a great interest by those state revenue agencies in looking at just this matter. When you switch over to the labor side, the Federal Department of Labor, or we call them the DOL, Wage and Hour Division, would be another agency that's involved in investigating this issue of independent contractor employee. And again, at the state level, the various departments of labor in the various state jurisdictions.
And sometimes there's another branch of the Department of Labor that gets involved, the Employee Benefit Security Administration, when the claim is that a person who is treated as a contractor is actually an employee entitled to benefits. And individuals, too, can bring private rights of action for benefits, Mark, so it's not always an agency that's bringing the claim. It can be an individual worker as well.
And there are two other agencies that we typically see in this area, and those are typically at the state level, and that would be the workers' compensation boards or bureaus. When a person gets injured and finds that they don't have insurance coverage for their injury, sometimes an investigation can be initiated by the Workers' Compensation Bureau or Board, as the case may be. And then the last agency area would be the unemployment compensation agencies or bureaus that, again, typically at the state and local level.
Let me go to a question that we have right out of the box from one of our attendees. We have a question: is there more protection in contracting with a company for resources as opposed to contracting with an individual? Does one of you want to take that on?
I'll go ahead and answer that. Yes, I think there are some benefits, and we'll drill into these a bit later when we talk about the standards. But when you're contracting with a company, normally, if that company is set up as a separate legal entity, it has to follow certain legal formalities. You are now contracting with a separate legal entity. Typically, that means that they're going to have a separate tax or federal ID number, and that also can be an indication that that entity is holding itself out to the general public as performing similar services. Now, I say that, but we want to qualify it that simply dealing with an individual who's incorporated is just one factor that these agencies will look at. It's a helpful factor, but it's not necessarily dispositive when you look at the entire substance of the relationship.
Okay. Well, let me just kind of drill down to something that I'm very interested in, and that is Did health care reform somehow affect the regulatory and enforcement environment on this issue? Gayle, let me ask you this. You're the employee benefits person.
Well, certainly it will, particularly as we approach 2014. Healthcare reform is only going to increase the regulatory scrutiny of independent contractor relationships, and that is because so many of the requirements in healthcare reform, particularly the employee pay-or-play mandate, turn on employee status. For example, that mandate to either provide coverage to full-time employees or pay a penalty applies to companies with 50 or more employees. So the question becomes, is that person, that worker who's been classified as an independent contractor, an employee who counts for that purposes or not? And also, when the mandate becomes effective, if someone is an employee, they'll have to be provided coverage or, offered coverage, or a penalty will have to be paid based on the number of full-time employees. So again, status becomes key. And the regulatory agencies that will be enforcing healthcare reform will really be scrutinizing relationships to see if companies are using the independent contractor label in order to keep down headcount, either to be not subject to the law or to lower their penalties or coverage obligations.
Okay. And Greg, let me ask you this. I mean, what would you say the regulatory environment is right now in this whole employee versus independent contractor debate? I mean, is it a tough is it a be careful environment out there, or what is it like?
Well, it is. I think be careful is a very good descriptor, because we're probably at an all-time high in terms of enforcement activity. And one of the things that I use to measure just how much enforcement there really is at a given time is the number of articles and commentaries that I see when we look at our daily advance sheets. And it is pretty common to see notable cases, commentary, that type of thing on a daily basis.
And can I ask you a question? How are companies getting in trouble? So you're seeing these reports of things going on.
Right.
What's happening to these companies?
Well, right now there's about 3,000 plus that are being audited nationally by the IRS alone. And typically what happens is somebody, it could be in the context of just a general audit, or somebody phones in a complaint, for instance, a discharged worker. A lot of times we've seen those investigations initiated by a current employee who may not be happy with, or a current worker, I should say, who may not be happy with various things. So that's what kind of triggers it in many cases. A lot of times it can be that the IRS just pulls up an employer ID number for just a generally scheduled audit. And one of the things they will take a look at is payroll information, independent contractor, 1099 filings, that type of thing. But
okay.
We are at a pretty high pitch right now for enforcement.
Is all of the enforcement done by the government agencies then?
No, I would say the bulk of it is, but what we're seeing across the country, particularly in the wage and hour area, is a good deal of private litigation, typically in what's called a collective action. Other people can call it class action, but in the wage and hour area we would call it a collective action. And what we're seeing there are claims for overtime, typically brought by folks who were classified as independent contractors by a company, only to later find that the person makes a claim, or person or persons make a claim for overtime that they say is allegedly due them because they were misclassified and should have been treated as an employee. And
another category of private actions you'll see are lawsuits under the federal employee benefits law known as ERISA. It gives individuals a private right of action to sue for benefits that they claim they should have been provided but were not provided. So someone originally classified as an independent contractor may say, hey, I was really an employee, I should have been offered health care coverage, or I should have been offered retirement benefits, or some other benefit that the employer made available to its employees.
Okay. And let me just encourage those of us who are listening to this to feel free to type your questions in to the Q&A box on your screen. and we would be happy to answer those for you at any time, even though may not be the topic that we're on at the moment. I would like to ask you now, let's talk about these standards. First of all, are the standards that we're talking about pretty much identical across the board?
I'll go ahead and field that one. They're not identical, Mark. Each agency typically has its own list of standards. And now, I would say there's a good amount of overlap when you take a look at these standards, because they basically focus on the issue of whether or not the company can direct and control the means and manner of the work to be performed by the worker. The IRS historically, back in my days when I was a CPA, we used to call the IRS test a 20-factor test, because they actually had a form that listed 20 different areas of inquiry to determine what the standards were, at least for federal tax purposes. That form is still around, by the way, and we're going to put up on the screen some standards that we've taken directly from that form. And the reason that we're focusing on that one is that it tends to be, the IRS standards tend to be pretty comprehensive, and what you would see at the various other agencies that we mentioned in this discussion already is some variant or derivative of these factors. And so hopefully you're seeing on your screens right now a slide that we've entitled IRS Multi-Factor Test. And we've kind of separated out these tests into various categories, and we'll drill down those in a second. But to your question, Mark, the standards vary, but when you take a look at this list, it's going to basically cover a good part of the territory that any of these agencies would be looking at.
And we have a number of slides here. I'm just going to kind of flip through them. These are what? Could you describe these for me generally?
Yeah, these are basically standards that talk about, we've categorized them as behavioral control. And you'll see that the top bullet point there, if we flip back to the prior slide, in fact, let's go to slide 5, Mark.
All right.
In this category of behavioral control, we've got 4 bullet points there. Without just reading these questions, essentially, the first area is, do we instruct the person in how to do their work? Typically, if it's an independent contractor, the IRS views it as, well, the company should really be more interested in the results of the work rather than how the work is actually carried out, how, when, that type of thing. And if the company were then to also do things like train the worker in certain processes, systems, that type of thing, that's an indication that the IRS feels might tend to show that person's more toward the employer-employee end of the spectrum.
Okay, so as we're flipping through these, we're not necessarily going to discuss every one. I think everyone's going to get a copy of this, a playback of this webinar, so you'll be able to freeze these on your screen or download them. So basically, these are all oriented, or at least it appears to me, as to trying to decide whether this person is a independent contractor or a employee. So these are the various things that they're looking at to make that determination. Is that right?
That's right, because the label itself is not important. Obviously, if someone is intended to be a contractor, they should be called a contractor, and any writings that evidence the relationship should call them a contractor, but just calling them that is not enough. And I should also mention that actual control is not as important as the right to control. So even if the employer doesn't actually give day-to-day instructions or doesn't instruct on the method and manner, if the employer if the company has the right to do so, that can be enough.
Interesting. So we're flipping through these, and it's just a great number of these things. And these are actually, a lot of them are common sense, that occurs to me. It certainly appears that way. What are the most common standards or issues that the agencies use in determining whether a particular working relationship is one of, are these the ones that are used, the employer-employee or independent contractor relationship? Is it the most common thing that we've just been looking at?
Yes, they are. And I think one that comes up quite often in these investigations is what I call the economic realities test. And that is, when you take a look at a worker, can it fairly be said that that worker or workers hold themselves out to the general public as performing similar services? If they do, and I think here at Baker & Daniels, we are kind of the classic independent contractor, because while we certainly work intensively with our clients, we've got numerous clients at any given time. And when you look in the telephone book, you have to ask, is the contractor or the person listed as holding themselves out to the general public as performing those types of similar services? Do they have their own business cards? Do they really operate like they're running a business? We had a question before about what if we contract with somebody who's incorporated? Well, that's an indication that normally a person that incorporates intends to do business with the general public. Now, again, I mentioned that that's not dispositive, but that's certainly a factor to look at. So the economic realities goes to the question of, does this individual or do these individuals actually perform services for more than one company, and are they similar services?
And Greg, I think there's another part to that economic reality test, and that is, I think agencies or courts look at how much the worker is treated like other employees, works alongside them, does similar work, or is it more like a vendor? And is the process for retaining that individual worker more like the process the employer follows when it retains the services of a vendor? Like, is there an RFP process or a bidding process, or is it more like the process they use when hiring an employee? So the similarities and differences between treatment as a vendor and treatment as an employer is another part of that gut check economic reality test.
Right, and I think on that, Gayle raises an important point. The more the worker does the work of the company, that is the integral work that the company is doing, the more I think the IRS and some of these agencies would say, well, that person's really not offering a service that is kind of tangential, for instance, like legal services or accounting services or perhaps maintenance services. They're actually doing the work performed by other employees, and there's really no substantive difference between what the independent contractor is doing versus what the direct employees are doing. Now, again, that's not dispositive necessarily if, for instance, we can show other indications that that worker really does those kinds of services for other companies as well. But it is one of the factors that the various agencies would look at.
And particularly if that person is doing something on a project basis that may not be part of the company's core competency, but a service that maybe the company needs to offer from time to time. So a contractor who does the service for others is retained on a project basis for a special assignment or a special project.
Gayle, let me just ask you this. We talked about what they're using to determine which category they come into, but how bad can it get? I mean, what are the sorts of scenarios in which businesses get into trouble from your perspective with worker misclassification?
A number of different scenarios. Let me talk about a couple of common ones that I see companies get into trouble. One is where they essentially hire individuals to do work very similar to the work of employees, but they classify them as contractors and call them contractors to reduce or limit their benefits costs. So they think, well, I'll hire a contractor because I won't have to provide them retirement contributions or health care coverage or paid time off. But in reality, they're doing very much the same kind of work as other employees and often working side by side. And so that's one of the most common scenarios where employers get into trouble. Another is where companies rehire retirees or other former workers but hire them as contractors, saying, well, you know, Joe worked for me for 25 years. He knows this business. He knows our work. I'm going to hire him on a project basis and classify him as a contractor. If Joe is really an independent contractor, that's fine, but many times what Joe is doing is exactly the same work that Joe used to do when Joe was an employee. And so the problem there becomes you're not withholding income and employment tax on what you're paying Joe. If Joe is not continuing to accrue retirement benefits and be able to make 401k contributions, if Joe is not offered health care coverage and Joe is really an employee, you can get into trouble both with the government and with Joe, who might decide after the fact that, yeah, I really wanted additional and was entitled to additional retirement benefits, or my health expenses should have been covered.
We've got a couple of questions from the attendees. What if you hire a temporary employee for a specific time period, such as 2 months for 32 hours per week? This is run through the payroll as a temporary employee and tax withheld. Person has been told no benefits with the temporary time. What do you say?
Let me talk about this, because this is another part. This is a related, not exactly the same question, but it's a related question, because temporary employees and contractors are all part of what we call the contingent workforce that come and go and yet are not treated the same as regular full-time employees. The problems you can get into here is, first of all, you need to make sure that if you're going to exclude temporary employees from benefits, you need to make sure that the terms of your benefit plans actually exclude them. That's what I call the phantom exclusion process. You tell them the phantom exclusion problem. You tell employees that as a temporary worker, you don't have a right to benefits, but there's no exclusion in your benefit plan that actually prevents them from being entitled to coverage or benefits. That can be an issue. Also, I see very often employers get into trouble with this slippery slope. They hire, if you do have an exclusion and you truly do hire someone for just a limited project on a very limited basis, you may be fine. However, there's always this slippery slope where the employee works a little longer, and the question becomes, are they really temporary anymore? I've seen a number of companies hire temporary workers but keep them for a couple of years. And there's really no difference between what that so-called temporary employee is doing and what regular full-time employees are doing, except that so-called temporary employee isn't getting benefits. So you have to be careful in the use of temporary employees that, first of all, the benefit plans are consistent with what you're telling them about their entitlement to benefits, and that, second, you have a good, careful definition of what a temporary employee is, and that you follow it and don't extend the temporary status so long that it's really not temporary anymore.
Okay, I've got another question here, and that question is, and this is a reaction, I think, to what we're hearing from the two of you, which is beware, be careful, it's a jungle out there, that kind of thing, typical lawyer stuff. So the response from one of our attendees is, then, to handle increased work volumes in our core business, is it more appropriate to hire part-time employees versus contractors? Greg, what do you think about that?
Well, I think generally the answer would be yes, and I think probably the best kind of analogy that we all see is during peak periods around the holidays, we always see the retailers kind of beefing up their workforces because of the increased work volume. Typically, those people that are hired are not independent contractors. They're part-time or seasonal employees. So I do think from a general perspective, it is better to default towards the part-time employees. But there's another alternative, and we see a lot of our clients doing this with the number of temporary workforce agencies, staffing agencies out there. A number of clients utilize those agencies to supply their employees. The benefit there is that typically those agencies handle administrative things like the workers' compensation coverage, payroll, that type of thing. If you choose to do that, go that route, I would recommend that our participants think about the agreement that they would sign with those types of agencies to supply those peak volume workers, to include things like an indemnity provision, so that if one of those workers were to pursue one of our participant companies, that you would have some indemnity backed up by insurance coverage. So, but the general answer to that question is yes. I think normally you would want to hire part-time employees rather than contractors, especially going back to one of the points we made before, if those workers are doing the similar types of work that your regular direct employees are doing.
We have another question here, and it is, what happens if the individual wants to become a contractor for reasons unknown to the company, like in the case of the retired employee? Any thoughts on that one?
Well, the question really boils down to, will they be functioning for your company as a contractor, or will they really be functioning as an employee but just want the label of a contractor because, for example, they may not want withholding, there may be other reasons unknown to you that they think the status is preferable for them. I mean, it really, again, boils down to what are they really doing for you. Just because
well, that's a classification issue, Gayle. I think what this guy's asking is, if you can't quite figure out what's going on, should you be suspicious? And
absolutely.
You should be.
Yes, because if they want to be classified as a contractor, but they really aren't, the employer many times is the one that's going to be left holding the bag, because much of the risk lays with the employer, not with the employee. For example, if the person doesn't want tax withholding, and that's the reason they want to be a contractor, and you don't withhold income and employment taxes, the government is going to go after the company before it's going to go after the individual.
Well, this kind of provokes my next question to you, and that is, okay, we've been talking about it being kind of a tough world out there. What kind of liability exists for misclassification? Let me start with you, Greg. How bad can it get?
Well, and I'm going to draw upon my time as an accountant. I was a tax accountant in back when there were what we used to call the Big 8 accounting firms, as well as my time in law practice. But what we typically see in terms of liability would be not only potential liability for back taxes that weren't paid, but interest, penalty, and attorney's fees sometimes if there's some claims for wage and hour violations, as well as overtime. And the difficulty is that what happens is a situation that may have come about very innocently results in multiple years of liability, and sometimes we would call it company killer liability, when you tag on all the accrued taxes, the interest, the penalties, and everything else that we've talked about. And sometimes we would have a situation where you would have more than one agency actually looking at a company, and these agencies have now become much better about sharing data. So sometimes you would have the IRS share its findings with the state departments of revenue. In some cases, we would also be dealing with the Department of Labor audit at the same time. So in the end, it becomes quite a snowball of civil liability.
And just to illustrate the additional liability that can come in the benefits area, I'm going to point to the most famous case known as the Microsoft case, Viscano versus Microsoft. In that case, Microsoft was using a number of workers that it called freelancers. And they signed independent contract agreements in which they, among other things, acknowledged that they were not entitled to benefits under any of Microsoft's plans. Well, lo and behold, a few years down the road, the IRS comes in and says these freelancers are really employees, and pursuant to a settlement, all of these employees get reclassified, all of these freelancers get reclassified as employees. They turn around and bring a class action suit against Microsoft, claiming that because they were really employees, they should have been participants in Microsoft's 401k plan, which had company stock in it, and Microsoft's employee stock purchase plan. And of course, everybody knows what happened to Microsoft stock. It went through the roof. So these employees, or these freelancers turned employees through reclassification, suddenly had this huge action for benefits that weren't extended to them because they weren't initially classified as employees, and they ended up being found entitled to those benefits, even though they had signed something that acknowledged that they weren't.
Now, if you've got a company I mean, a company in good standing, and we're nearing the end of our time, and we're going to be asking for questions soon, but I'm kind of curious of the answer to this question. If you've got a company in good standing, then you, the business owner, are not going to be liable for any of these problems, are you?
Well, that's actually a very good question, because it's become very common these days, or I should say more common than in the past, for some agencies, as well as private plaintiffs' lawyers, to go after individual officers. And let's just take the tax side of it. There is, under the tax code, the notion of somebody called a, quote, responsible person or responsible party. And the code allows enforcement for payroll taxes, believe it or not, to be enforced not only against the company, but potentially against those responsible persons who are charged with the responsibility of paying over and accounting for taxes. And we have seen enforcement at that level against individual officers in the tax side. Now, if you flip over, we talked a little bit about the Department of Labor and the wage and hour audits. Interestingly, in the wage and hour area, the Federal Fair Labor Standards Act is a category of labor law that also presents the potential for individual liability. In that regard, it's a little different than other types of labor laws that apply typically only to the company, the corporate entity. The wage and hour laws at the federal level, and this can be true also at various state levels, depending on what state you're talking about, can actually impress individual liability for wage and hour violations. And it has become more and more common for certain plaintiffs' attorneys, when they file suit, to not only bring the case against the corporate employer, but also against individual officers, to do two things. One, ratchet up the irritation value of the case, the potential for settlement. Sometimes that's done to destroy what's called diversity jurisdiction in order to force the case into the state court system. But to answer your question, yes, there can be individual responsibility for some of these liabilities.
All right. Okay, let's very quickly get into what we can do to manage and mitigate risk here. Can you give me just a few bullet points, very briefly, on what businesses can do to reduce the risks of misclassification, including benefits-related risks? Gayle, why don't we start with you?
Well, one thing is very careful language in your plan that will exclude people from participation, not based on what they actually are or might be reclassified to be, but the way the company initially classifies them. So you avoid the Microsoft problem. Microsoft could have avoided a lot of that liability had it had more careful plan language. So that's, and we talked about temporary employees too, making sure that you have exclusions. If you're not going to offer temporary employees benefits, having language in your plan that actually excludes them. And then there are just a number of other things you can do to try to mitigate risk of misclassification, among other things. Differentiating contractors from employees as much as possible, both in the work they do, where they do it, the degree of control you exercise or have the right to exercise over them, having written contracts that acknowledge their contractor status, selecting contractors, like our one question, selecting contractors who also work for others, and hold themselves out as working for others, and hiring contractors through a process more like hiring vendors than like hiring employees, and avoid, where possible, rehiring retirees and other former employees as contractors unless they truly have bona fide businesses.
Okay. And related to that, just to clarify, this is a question from the group. Just to clarify, we hire individuals, independent contractors, who have set up their own company in which they invoice us under their company for their time and expenses, and we of course pay those expenses. We pay them for that invoice. They are absolutely doing exactly the same thing as our full-time employees. Part of our agreement with them is that we don't pay benefits for them. So in essence, we only pay them an hourly rate for hours worked. So we are treating them like a vendor. How does that work in response? What do you think, guys?
Well, certainly the way you have set them up and are paying them is one factor that will be considered, and not paying them benefits is one factor that will be considered in your favor. However, going against you, as the nature of the work is similar to employees, one thing that's really important is to what extent does the contract with them give you the right to control when they do their work, where they do their work? Do they do the work at your place of business? Do they do it on their own? Do you say, need to be here to do the work from 9 to 5 or whatever your hours of work are, or can they determine where and when they do it? How much supervision do you have the right to exercise over them? And you're paying them on an hourly basis rather than a project basis. That's another factor that goes against you. If you were paying them more on a project basis so that they had some risk of profit or loss, so that they would assess essentially what they're likely to, what they're going to charge you for the project, including their expenses, and so that they have a risk of, they have an upside and a potential downside, that is more likely to be seen as a true independent contractor relationship than an hourly pay where they have, and reimbursement of expenses where there's really no downside risk to them. Okay, and we have from one of our attendees the reminder, don't forget the uncovered workers' comp losses. What would you say to that, Greg?
Yeah, and I think that when we talked earlier about the range of agencies that look at these things, the workers' comp agencies and their interest is, and we mentioned this issue of somebody being injured at work, if you have somebody who is not classified as an employee and they are on your property or in the course of doing your work as a company and they're injured, typically what we see is somebody then saying, well, since I don't have insurance coverage, I'm now going to raise the issue whether I was really a de facto employee. And the question is an excellent one, because if you have not identified that worker or that group of workers to your insurance carrier as covered risk persons, what you may end up with is an uncovered workers' compensation liability, and with the medical costs and what have you, that can get into the large dollars very quickly. So the issue of classification is very important also when it comes to making sure that if there is some sort of injury or fatality, that it is covered under properly under the workers' compensation umbrella, or you are very confident that that person is indeed an independent contractor that ought to be furnishing their own insurance. And that brings up one kind of collateral point. If you truly have an independent contractor relationship with a group or of workers or an individual, and there's no question that they are properly classified as an independent contractor, when they come onto your business premises or when they're doing business for you, they're kind of like a business invitee under most jurisdictions' laws. Consequently, the issue is if there were something that occurred to them, an injury, some sort of property loss, do you have sufficient general liability or premises liability coverage to take care of that? Or should you ask for some sort of indemnity from that person in terms of their doing business with you? Those are all factors that I think come in. It's really not part of this discussion today, but things to think about. Okay, I think we've kind of done a lot of talking here, and we've gotten some very good questions from the attendees in writing. Let's try to open up the phones now to those who may be able or want to communicate in that method instead of the typing method. And typically this results in 0 questions, and that's totally cool because we've run out of time anyway. But why don't we go ahead and open up the phones?
They are now open, gentlemen.
Okay, so
and ladies.
If you have your phone muted, unmute it and ask a question if there's anything that occurs to you, and we will try to answer your questions. So speak now or forever hold your peace. free legal advice being offered now at the price of $0. Going once. Going twice. Well, John, let us turn it back over to you. Do you guys have any closing comments or anything you want to make?
Sure.
I would close with this, and that is, if you are sitting out there presently and you're wondering whether or not you have properly classified any worker or group of workers, what I would suggest is most of you have relationships with counsel or accountants. I prefer counsel, even though I am kind of a former CPA, because the advice you get from your local lawyers would fall under the attorney-client privilege, and the accountant-client privilege typically isn't as a high level of protection. But you may want to have some independent view given to you as to whether or not a particular worker is an employee or properly classified as an independent contractor. And that's something to think about as you move forward. And if you have questions, that's a possible resource that you may want to consider.
Gayle, any final points?
Just to reemphasize one, although we've talked about multi-factor tests, and all of these really are facts and circumstances tests. And although the agencies say, and the courts say, there isn't one factor that's determinative, the most important factor is that right of control, the right to control where, when, and how a worker does his or her work. So when you're looking at a relationship and you want to maximize the extent to which they're likely to be found an independent contractor, limiting that right of control is very important.
And I just got a question from that really goes to John, and the question is, did you say that we will be getting a copy of the presentation? And I think that's critical if you want to see the multi-factor test that the IRS uses. And John, why don't you answer that and then take it from here? 'Cause I think
sure. Well, that's as much really up to you, Mark, and your team. If you could send your presentation slides to Jeannie Rosen at the CSIA, she can post them on the same page where the recording will be posted, and everyone will be getting a link to go to that page.
Mark, let me just say one last thing. For the folks that have internet access, they can go to the IRS website. They can actually pull up this form, and it's called the SS8. It's SAM8, SS8. If you go to the, I think it's irs.gov website, and you can find that form, and you can actually see these questions right on the form itself, and a few others that we've kind of taken out that were more general in application. But that's a form that is accessible by anybody that has internet access.
Right, and Mark, I thought of one other point I want to make, and that is if you are currently using any kind of contingent workers, independent contractors, temporary employees, or leased employees through an agency, it's very important to check your plan language to be sure that if you are excluding these folks from your benefits, there is language in your plan that excludes them. And it's real important to work with your counsel, sometimes not just your vendor through whom you might get the plan, but actually work through your counsel to be sure that the plan language is consistent with the way you're treating these folks.
One more question from the attendees. Is there a specific time frame that would be considered temporary? 3 months, 6 months, 1 year?
No, unfortunately, there's no hard and fast rules on this. It's important that you define it for your company. My general advice is no longer that if you're hiring the temporaries directly, not through an agency, no longer than 6 months is a good rule of thumb. If you're hiring them through an agency, special rules apply if the same worker works for you for a year. So typically you'll want to, a year if you're hiring them through the agency, no more than 6 months if you're less than a year if you're hiring them through an agency, less than 6 months if you're hiring them directly. But that's just a rule of thumb. That's not always determinative.
John, we'll hand it back to you.
All righty, very good. Let me get the presenter ball back here. All right, well, to all of our attendees, thank you for your participation. My hope is that you got several good ideas that you can implement to benefit your company and keep the government happy too. Mark, Gayle, and Greg, thank you for your contribution of your time and expertise. Your presentation was very insightful, and we wish the best for all of you. Thanks again to our host and sponsor, Software Toolbox. Be sure to complete the survey for today's webinar. It will arrive in your inbox within the hour. Your feedback is necessary for CSIA's continuous improvement, so please complete it immediately. September's webinar is by Keith Martino, President of CMI in Dallas, Texas. It will be September 29th, and details will be published soon. Keith works with several of our members, so is quite knowledgeable of our CSI industry. So in closing, here's a CSIA bullet list for you to consider. Watch for information on the new partner member library to be announced soon. It's for integrators too. Take advantage of some of the upcoming sales training. Take advantage of the upcoming boot camp to learn how to prepare for an audit. If you ever have a suggested topic for a webinar, please send it to Bob Lowe, the CSIA Executive Director. Have a productive rest of your week. Thank you all again, and goodbye. And we're now clear.